Ladies and gentlemen, I welcome all to my channel. Today we are going to discuss about the settlement and its cancellation. Whether we can cancel a settlement or not. Whether we are entitled to cancel the settlement once it is registered properly with the register office. Whether a person who make the settlement is legally entitled to cancel the settlement are all the questions which is to be discussed today in this topic. You know very well what is meant by settlement. Settlement is the transfer of the property from one person to another person by way of a document called settlement deed. It can be made for consideration, or it can be made for some conditions, or it can be made out of love and affections. Before considering the legal principles which enables the cancellation of a settlement, I will give you a small case which I have seen in my life. One gentleman purchased a property in his wife's name. The wife, the husband died, leaving his wife and 3 daughters. So the property stands in the name of wife, that is the mother of the 3 daughters. What happened? One of the daughter took mother and she maintained her for some time, and after a period of time she requested her mother to make a settlement deed and asked her to register the property in her name as she is maintaining the mother. The mother also believed the words of the daughter and made a settlement deed and settled the property in favor of the one daughter. After a period of time, as she has comfortably received the settlement document and the property document, she thrown away her mother. So the helpless mother came out of the daughter and she has gone to the second daughter. The second daughter took her and she maintained her mother for a period of time, and she came to understand what has happened with the first daughter. When she said that she has executed the settlement deed in favor of the first daughter, then the second daughter said, No, ma'am, the first daughter has thrown you out from the house. So now onwards I am going to maintain you. So you cancel the settlement deed which is made in favor of the first daughter and make a settlement deed of the same property in my favor, like what the second daughter requested. So the helpless mother, as she was in the care and custody of the second daughter, she has done whatever was dictated by the second daughter, and accordingly she went to the register office and cancelled the previous first settlement deed and made a second settlement deed in favor of the second daughter. After a period of time, say about 3 or 6 months later, the second daughter also did the same things to her mother. So the second daughter thrown the mother out of home. So the helpless mother went to the third daughter and stayed there with the third daughter. The third daughter also did the same things like what the second daughter did. She has took the mother to the register office and cancelled the settlement deed in favor of the first daughter. and finally, and also made a fresh new third settlement document in favor of the third daughter. Now, there were 3 settlement deeds. First one is in favor of the first daughter, second one is in favor of second daughter, and third one is in favor of third daughter. The first settlement deed was cancelled by when they executed the second settlement deed, and second settlement deed was cancelled when she was executing third settlement deed. So now, this is what happened to this client. Strictly speaking, in most of the register office, they will not allow cancellation of the settlement deed. But in practice, you know very well what will happen if you pay some money to the registrar, or if you corrupt the people. Anything can be possible. So in this case, the same registrar, then the same register office, 3 settlement deed has been registered, and it has been cancelled for 2 times. Now this is a question of law. Which document, which settlement is valid, which settlement is not valid? It is a question to be decided by the court. So when they ask me the question, sir, which settlement is valid, it is to be properly to be decided by the court of law, because court alone can say which one is right or which one is wrong on seeing the facts and circumstances of the case. Practically speaking, this kind of things is not practically possible, but still this type of things are happening. So the settlement deed, often registered by one time, is being cancelled for a second time, like what the process is going on and practice is going on in our state. Now the question is whether such cancellation is valid, whether a person who makes a settlement can cancel the document, like what happened in this case. If such things to be allowed, then it will be easy for the executor to make a settlement deed one day, and after a week's time, he can simply come and cancel the settlement deed. And if such thing is allowed, then it will be great risk to the society. Assuming for a moment, the same cancellation procedure is allowed to the seller for the sale deed, what will be the result? Assuming for a result, assuming for the consequences, so just think about the consequences. Supposing you are going to the builder, you pay money, he is execute a sale deed, and we are comfortably staying in the house, saying that we got a sale deed and we got a possession of property. After 3 months, the builder went to the register office and makes a cancellation deed. If such thing is allowed in the register office, then nobody can enjoy the property, right? So what is the law regarding such things is not practically possible for a sale deed. But for settlement deed, in many register offices, such things are being allowed. The registrar encourages such state of cancellation, and registrar that did not prevents such cancellation. And the registrar wrongly thinks that he has the authority to allow the people to make a settlement deed, cancellation deed. So ultimately, when there are 2 or 3 settlement deeds and when there are 2 or 3 cancellation deeds, the ultimate authority to decide the issue, to say the right thing, to dictate which is correct, is to be properly declared by the court of law. Because we are not supposed to give a proper answer to this question. It is to be decided by the court of law on case-to-case basis. If the case comes to the court, what will be the consequence? See, for the settlement, as far as settlement is concerned, it is purely like a gift. A person who gives the property called donor out of love and affection or for any other reason, to another person who is called as donee. So donor gives the property and donee takes the property and he enjoys it. And the thing is completed. So as far as the legal principle is concerned, as per the settlement, whether it is a settlement or whether it is called as a gift, 3 elements should be completed. 3 elements is to be noted. The first one is there must be a donor, giver, who gives the property. So that person should have the capability, eligibility, rights over the property to give the property to the other person. So if a person, supposing a person, my father gives the property, wanted to settle the property to his son, first son, excluding the other children. In that case, he should have the full right, absolute right, interest over the property. The father should have the absolute right, title, interest over the property. He should also have sound mind. So if this element is there, first point is complete. Second point is that the person who receives the property, the donee or the settlee who takes the property, should accept the gift. Supposing I give my money to you, if you accept it, it will transfer. If you say, if I give you money and you say, I don't want, then it will not transfer, it will come back. It's a simple principle. So the legally speaking, if you are making, once a person is making a settlement, he has to give the property, then the other person has to receive it. He has to accept. Yes, I accept the settlement. Like what? They have to take the property. So just to throwing the property will not go and reach the other person. One person has to give, the other person has to accept. So that is the second element. The third element is the delivery of the property. Possession of the property to be delivered. So if a person simply says, I am going to settle the property to my son, he will take it after my lifetime. In that case, it cannot be considered as a transfer. Transfer didn't take place. If a person say, I will give this property after my deaths, I will till my stage, I will enjoy the property. If you say like that, here the property is not transferred. Property is not gone. He simply says, I will give it after my lifetime. If such type of words were used in a settlement deed, then it will be considered only as a will, not as a settlement deed. In settlement deed, the property and ownership has to be transferred, to be settled to the other person. So, person giving the property is called settler. The person receiving the property is called settlee. So, one person has to give the property and other person has to accept or receive the property. If these 2 elements are completed, the property is transferred. In addition to that, the possession of the property should also be delivered. Now, if when you say that possession of the property, it can be legal possession or physical possession or symbolic possession. What is meant by legal possession or what is meant by physical possession or what is meant by symbolic possession? Assuming for a moment, if there is a vacant house, if a person, father gives the property to the son and gives this vacant possession of the property, it is called physical possession. Physically delivering the property. So once the physical property is delivered, then settlement is complete. Sometimes there may be some tenants occupying the property. Here, the person gives the property may not be in a position to give physical possession because already it is occupied by some tenant. Here he can say and confirm that I am delivering the possession. I am delivering the personal property to you under this deed. You can take this possession and you can transfer the tenancy and you can attorn the tenancy and you can transfer the tenancy in favor of you. So if you put a wordings like this, strong word confirming the delivery of possession, it is called legal possession. Legal possession means instead of physically delivering the possession, by words, by legal words, they can confirm the delivery of the possession to the property to the settlee. Another thing is symbolic possession. Symbolic possession, see for example, when the builder is in a position, when the builder transfers the property, sell the property, he will, once the registration is complete, he will give the keys of the property in the register office itself. So once the key of the property is given, it's a symbol, symbolically is confirming the delivery of the possession. So once the key is delivered from the buyer to seller or settler to settlee, donor to donee, automatically the person who receives the key, he can come and open the property and take possession, enjoy the property, take control of the property, can take control over the possession of the property. So here it's called symbolic. So once the settlement is completed in all the in all the three aspects, settler having title over the property, interest over property, settlee accept the property, and the settlement is completed by delivery of the possession, then legally speaking, the settlement is complete. The settlement is totally completed. Once the settlement is completed, then it cannot be reopened or it cannot be cancelled or it cannot be modified. Once you take the food, till it is in our mouth, we can throw it away. Right? Once you take the food and it has passed through the mouth and it has come to the stomach, then it is not under our control. Like what? Once the settlement is deed and registered and the possession of the property is also delivered to the settlee, to the giver, whether it may be a symbolic possession, legal possession or physical possession, once it is completed, then once given is given, it cannot be taken back. It's the principle which is followed in the court of law. So once the settlement is completed in these three aspects, once the delivery is totally completed and gift is accepted, a person should give a gift, the other person should accept the things, and it has to be delivery of the person should also be given to the receiver. Once these three elements are completed, then the settlement cannot be cancelled, it cannot be modified, it cannot be taken back, and in spite of that, you go and make a cancellation deed and register it, it will not be valid. This is a principle for, this is the law as on, which is existing as on date. So simply we cannot cancel a settlement deed once the possession is completed. Once the possession, delivery of the possession is completed. Supposing the settlement is given on some condition, saying that I am giving the settlement deed and I have a right to cancel this settlement deed, I can revoke this settlement deed, and they also put some conditions saying that I am giving this property as a consideration that my son should maintain the father and mother till the lifetime. They have to give me the proper food, shelter and maintenance, everything. Suppose he fails to make any such provisions, fails to maintain the father's parents, fails to maintain the sisters, brothers, like that, then I am entitled to cancel. Like what? If any such condition is met. So once if any such condition is imposed and the receiver violated the condition, in that case, the settlor can cancel the settlement deed because it is not a completed settlement, it is a conditional settlement. So conditional settlement means a settlement which is made on a condition. You should do this, you should do this, you should do this. If you are agreed to do all these things, you can take the property. Supposing father says, I give this property to my first son on a condition that my first son should maintain my two daughters, two sons, and they have to provide all educational expenses to all the four children, and he has to provide all. You have to bear all the expenses for their marriage. If on this condition only I am giving this settlement deed. Like what if the father makes any such settlement deed, then the person, the first son who is receiving this property should honor all the conditions stipulated therein. If he fails to, if he say I will not accept these conditions, I will only accept my property, I will not ready to accept the condition, means he cannot accept. The offer, the preparedness of the father itself is with the condition. I am giving this property on a condition that you should do this thing. So in that case, the son can accept the property only if he is prepared to accept all the conditions also. He can accept both the conditions as well as the property. In that case, then only he give the property, he can take the property, he can take control over the property. If he violates the condition, then the father has every right to implement the condition, or he can, in case he is failed to refuse to comply those conditions, he can also go for a cancellation of the document, provided that condition is properly incorporated in the settlement deed. So, for all purposes, settlement deed cannot be cancelled easily, like what happened in the case. Even if such way of registration of the cancellation deed, that such cancellation will not have any effect, because once the settlement is completed, once complete, it's always completed. It cannot be taken back. If the conditions of the settlements are not properly complied, or if it is not properly followed, or if the delivery of the possession of the property is not completed, then till such delivery, the settlor has every right to cancel the settlement deed. So if such cancellation is done on those circumstances, it can be valid. So I hope this video is useful to you, and so you may give your comments, opinion about this video. And if you have any other legal doubts or clarification, you can watch my other videos in my channel. I upload various videos in my channel that will be helpful to you, and you can clarify yourself. Knowledge is power. By acquiring legal knowledge, you can not only make yourself powerful, and you can also get confidence in your life. So you may watch my channels regularly. You will get not only strength but also the confidence in your life. In addition to that, if you have any other legal doubts, clarifications, consultation, you can also contact me to my cell number for any legal opinion or legal assistance or legal clarification. I hope this video will be useful to you. You may subscribe my channel. You may also share this video to your friends, which may be helpful to them. And I will come again with another topic. Until then, goodbye. Raziaq.